Frank Borghese of Graham and Borghese. We've defended hundreds, if not thousands, of lawsuits by creditors over the years. And what we can tell you definitively is that you need to have a very clear understanding of what the legal procedure is and what your arguments and defenses are when it comes to litigation. I can't tell you how many times we've gotten calls from people who tried to handle litigation on their own, and we were very disappointed to discover that a lot of times they introduce things or they engage in interaction with the plaintiff's law firm that really has no impact in their case. And in many ways, it prevents them from obtaining that result they were hoping to achieve initially. Let me give you an example. One of the most common things that I hear from people who call our office is that they submitted an answer on their own. And when I ask them for a copy of the paperwork, what they provide is usually some generic statement that says something along the lines of, I know I owe this debt, but I just don't have the money to pay. Or, I know I owe the money, but I've reached out to the creditor and they won't work with me, or they're not being reasonable. And I can tell you very definitively that this is not going to help that person. What happens is, when a lawsuit's filed, the creditor is telling the court a few basic things. They're trying to argue, one, that you agreed to take out a debt, and two, you agreed to repay the debt, and three, that you didn't repay the debt. So when they're filing a lawsuit with the court, the only types of defenses that you can raise are arguments that attack one of those three phases or elements of the litigation. When you say things like, I know I owe the money, but I can't afford to pay it, it's not a valid legal defense to the lawsuit. And in fact, you're essentially admitting that you have liability on the account. You're not contesting anything regarding the amount of the debt. You're not even contesting the person or company that's coming after you for payment of the debt. So what happens in that instance is you've given a green light to the creditor and their attorneys to get a judgment against you, and now you've admitted to owing the money, and you've put yourself in a very, very delicate situation where you have very little leverage to resolve the account. Our office is extremely well versed in all of the affirmative defenses you can raise, whether you dispute owing the money because of services that weren't provided, or you dispute the charges that were issued, or you're dealing with identity theft, or you believe that the creditor waited too long to sue you or inflated the debt. These are all things that we can put forth on your behalf if we file an answer. And I urge you to give us a call before you take any major action on your behalf in a lawsuit. You only have a limited amount of time, and that's dictated by how and when you were served with notice of the lawsuit. So if you've received a summons and complaint, give us a call right away. We'll provide you with a free consultation. We'll explain the procedure for your particular court, and we'll make a proposal for you so that there's no pressure to retain our services right away. If you decide that you'd rather go a different way, that's perfectly acceptable, but we want you to at least consider what the benefits of hiring our firm are and allow us the opportunity to put our experience and knowledge to work for you. We hope to hear from you soon, and thank you for taking the time to watch this video.
So remember, for your debt relief made easy, call Graham and Borghese.